Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Go to Massachusetts. This is really good news. This is exciting. It's so as viewers may know, in Massachusetts and Syracuse, New York, a number of cities, I don't know how many, but at least three, have had consent decrees where they found, historically, this one goes back to 1972, but where they found that the hiring practices of a municipal fire department, police department, et cetera, were not consistent with that the percentage of population in the community. In other words, the community may have 30% African-American, but the fire department only has 5%. And they're saying that doesn't make sense. Clearly something's out of line. You should be hiring to the, the same percentage. So back in 1972, they put in these quotas, racial quotas, really interesting way on how they do it. You create two groups, A and B, and they say, okay, we're going to choose somebody from the white people group A, and for every three that we hire on the white people group, you need at least one in the the African American group. In any event, they the court said that, look, they've reached their goal and we don't need the decree, and it will go away in 2024. So kudos. And the reason they're doing that, if anybody is sitting saying, well, why would you get away from it? This has Roe v. Wade consequences. Listen to the language. I know people are saying, Roe v. Wade, why are you talking about Roe v. Wade? Yeah, and the more recent case, but listen to the language. So what the federal court says is, listen, a race-conscious remedy, which is what this is, must survive strict scrutiny. In other words, it must be justified by a strong state interest and narrowly tailored to achieve that interest. And the federal government should stay out of it once it's solved. So, and they talk about, this is where my point is about Roe and states' rights. The court says an intrusion by a federal court into the affairs of local government should be kept to bare minimum and not be allowed to continue after a violation has been abated and its pernicious effects have been cured. In other words, federal government, says the federal court, stay out of it, let the local government deal with it. And that may sound to some like the federalism, right? Federal versus state, Roe v. Wade, the whole abortion issue. So that's why I bring it out. It's the federal tests recognize will lay a heavy hand to solve a local issue, but once the local issue is solved, the federal government needs to get out. I don't know that our current federal government would believe this, but nonetheless, and that was good.
Well, I think it was 50 years, and that's a long time for a consent decree. There's no maximum limit on them. And this one actually got extended a little bit because there was a couple of little hiccups along the way. Their 3-for-1 hiring actually ended up because of some population shifts.
Became
the
1-to-1
hiring actually worked against the minorities, and so they had to make some adjustments there. But some of the cities, the bigger cities like Boston, they were 1-for-1 hiring. They weren't 3-for-1. They were 1-for-1 hiring. And then most of the other cities were 3-for-1 hiring. So at any rate, the ruling now, the NAACP was the plaintiff in the case, and they actually wanted it. Let me just see. I think they wanted it extended for another 15 years, I think. Or they wanted to extend it until 2040, I think.
Yeah, and that was where the response of, listen, the federal court needs to get out. The federal government needs to get out once the issue isn't an issue anymore.
That's right. The NAACP sought to extend it for another 18 years. So it's 2022 now. They wanted it to go until is that my math right there? Yeah, 2040. And the court said, no, 50 years is enough. It's been in place 50 years. We don't need to go to 70 years.
Successfully in place, right? Not just because it's been in place, because it's been successful and has cured the issue.
Yeah, I at least percentage wise. And I think over the years, our understanding of the proper way to test and evaluate and score those processes has improved to the point where there's enough processes out there that don't have any sort of discriminatory effect, so that if you put folks in a room, everyone's going to be on an even keel, that we're not going to see a lopsided score with white scoring very high and minority scoring low. So I think that our understanding of how to test and how to evaluate people is much better than it was certainly 50 years ago, even 20 or 30 years ago.
But you can bet the NAACP or other watchdog groups will be watching to make sure that the cities stay
as they should.
as they should.
As they should.
As they should.
As
Absolutely.
they should.
Okay.